Hello and welcome. I am Juliette Rizzo, and I will be talking with Renee Bradley and Michael Slade from the Office of Special Education Programs, or OSEP, about the final Part B regulations implementing the Individuals with Disabilities Education Act, or IDEA. We'll be talking about the provisions relating to discipline. Welcome, Renee and Mike, and thanks for being with us today.
Hi, Juliette.
I understand that there are some changes in the discipline provisions in IDEA 2004 from the provisions in IDEA 1997. Where should we begin?
There's a lot to cover, so let's jump right in. Of course, the final Part B regulations encourage the use of positive behavioral intervention and supports, or PBIS, to manage behavior before it's necessary to move to discipline provisions. The OSEP-funded National Center on PBIS at the University of Oregon works with states and schools to support PBIS practices. But the final regulations continue to recognize that there will be situations where PBIS is not enough and discipline provisions are necessary. The regulations give school authorities, added flexibility in disciplinary situations. That flexibility might be a good place to start. The final regulations ask school personnel to consider any unique circumstances on a case-by-case basis when determining whether a change in placement is appropriate for a child with a disability who violates a code of student conduct. In addition, the preamble explains what constitutes a unique circumstance is best determined at the local level by school personnel who know the child and know all the facts and circumstances about a child's behavior. When determining whether a disciplinary change of placement is appropriate, a range of factors should be considered. Questions that might be asked include, what is a child's disciplinary history? Does the child have the ability to understand consequences? Has there been an expression of remorse? Were supports provided to the child before the violation of a school code?
And in addition to removals related to drugs and weapons, there also is a new removal authority related to serious bodily injury.
I'm familiar with the provisions for drugs and weapons. Is this new provision similar to those?
Yes, it is. Like drug and weapon offenses, school personnel may remove a student to an interim alternative educational setting for not more than 45 school days.
And this removal can occur without regard to whether the behavior is determined to be a manifestation of the child's disability.
That's right. This is a new authority can be invoked if the child has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function under the jurisdiction of a state educational agency, or SEA, or a local education agency, or LEA.
Do the regulations define what is meant by serious bodily injury?
The statute and regulations define serious bodily injury as bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty.
That certainly sounds serious. Are there any changes regarding removals for drugs or weapons?
No, the provisions in the final regulations remain the same for drugs and weapons. However, it should be noted that under these provisions, a child could be removed to an interim alternative educational setting for not more than 45 school days, which is different from the 45 calendar days in the previous regulations.
What other major changes occurred in the discipline provisions?
As Renee mentioned, the final regulations retain provisions regarding short-term removals for less than 10 days in a school year and long-term removals more than 10 consecutive days in a school year. The regulations also clarify when educational services may need to be provided during such removals and the standards that apply to those services.
Can you say more about that, Mike?
Sure. In general, for long-term removals, children with disabilities must continue to receive those educational services that are necessary to enable the child to continue to participate in the general education curriculum and to progress toward meeting the goals set out in the child's IEP. However, the educational services provided under these discipline provisions do not need to be exactly the same services in exactly the same settings as were provided before the implementation of the discipline provisions.
So, can you clarify when these educational services may be required for short-term removals?
Yes, A public agency is only required to provide services to a child with a disability who has been removed from his or her current placement for 10 days or less if the public agency provides services to a non-disabled student who is similarly removed.
What about other disciplinary removals, like those that occur after the child has been removed for 10 school days in that school year, and those that are for more than 10 consecutive school days?
In general, the final regulations provide that once a child with a disability has been removed for 10 school days in the same school year during any subsequent days of removal, the public agency must provide those services necessary to enable that child to continue to participate in the general curriculum and to progress towards meeting the goals set out in the child's IEP. School personnel, in consultation with at least one of the child's teachers, determine the extent to which such services are needed for a child previously removed for 10 school days in the same school year and who is later removed for a period of not more than 10 consecutive school days, and that subsequent removal is not considered a change in placement.
If a removal is considered a change of placement, the child's IEP team makes the decision about the educational services to enable the child to continue to participate in the general curriculum and to progress toward meeting the goals set out in the child's IEP.
I know that the final regulations sometimes use the term removal and sometimes use change of placement. What is the difference?
Not all removals are considered a change of placement. There are multiple parts to the definition of a disciplinary change of placement, so you may want to look at Section 300.536 of the final Part B regulations. A change of placement occurs if a removal is for more than 10 consecutive school days.
Or a change of placement occurs because the child has been subjected to a series of removals that constitute a pattern.
What does that mean?
A series of removals constitutes a pattern because the series of removals totals more than 10 school days in a school year, and the child's behavior is substantially similar to the child's behavior in previous incidents. Also considered are such factors as the length of each removal, the total amount of time the child has been removed, and how close the removals are to one another.
The final regulations now specify that the public agency determines on a case-by-case basis whether a pattern of removals constitutes a change of placement. This determination may be reviewed under the due process and judicial proceedings.
These are very detailed provisions and very complex. How do parents know what is happening with their child in these various circumstances?
It's important to keep the parents involved and to let them know what is happening as soon as possible. If there are issues such as where the behavior impedes the child's learning or that of others, the IEP team members must consider the use of positive behavioral interventions and supports and other strategies to address the behavior. The IEP team, that includes the parents, can incorporate positive behavioral interventions and supports into the child's programs. With regard to disciplinary removals, one safeguard in the regulations provides that on the date when a decision is made to make a removal that constitutes a change of placement, the school district must notify the parents of that decision and provide the parents with a copy of the procedural safeguards notice. The procedural safeguards described in the notice include the right of a parent to request a due process hearing by filing a due process complaint, a process we'll discuss a little bit later.
Have any changes been made to the manifestation determination provisions? How manifestation is determined?
Yes, there have been a number of changes to the process for making a manifestation determination. The final regulations clarify that a manifestation determination must be made within 10 school days of any decision to change the placement of a child with a disability because of a violation of a code of student conduct.
Does the child's IEP team make this determination?
Not exactly. The LEA representative, the parent, and the relevant members of the child's IEP team must review all relevant information in the student's file. This includes the student's IEP, any teacher observations, information provided by the child's parents. The LEA and the parent determine who those relevant team members are.
What is the standard used to determine whether the conduct in question is or is not a manifestation of the child's disability?
It must be determined if the conduct in question was caused by or had a direct and substantial relationship to the child's disability.
There's also another provision. The conduct in question could also be determined to be a manifestation of the child's disability if it was the direct result of the LEA's failure to implement the child's IEP.
That's right, Mike. And if it is determined that either one of those conditions is met, then the conduct that led to the removal must be determined to be a manifestation of the child's disability.
And if it is determined that the conduct in question was the direct result of the LEA's failure to implement the IEP, the LEA must take immediate steps to remedy those deficiencies.
There's also a provision related to procedures when the group determines that the conduct was a manifestation of the disability.
Can you describe that provision?
Sure, Juliet. If it is determined that the conduct was a manifestation of the disability, the IEP team must do one of the following: either conduct a functional behavior assessment and implement a behavior intervention plan for the child, or if the LEA had conducted a functional behavior assessment before the behavior occurred, then implement a behavioral intervention plan. Or if the behavior intervention plan already has been developed, review the plan and modify it as necessary to address the behavior.
What happens to the child's placement if the behavior was a manifestation of the child's disability?
Unless the removal was related to violations for drugs, weapons, or serious bodily injury, the child must be returned to the placement from which he or she was removed. However, the parent and the LEA can agree to a change of placement as part of the modification of the behavioral intervention plan.
What's different about drugs, weapons, or serious bodily injury?
In these cases, school personnel could remove the child immediately to an interim alternative educational setting for not more than 45 school days, without regard to whether the behavior is determined to be a manifestation of the child's disability.
I'm beginning to understand why there is a need for a case-by-case determination here. There are a lot of factors that interconnect, and it would be unlikely that two situations would have exactly the same set of circumstances. Didn't the previous regulations talk about protections for children who had not yet been identified as eligible for special education and related services? Is that provision still there?
Yes, it's still there, but with some clarifications. If a child has not been determined to be eligible for special education and related services under Part B and has engaged in a behavior that violated a code of student conduct, that child may assert any of the protections under these discipline provisions if, and this is not a change, the public agency knew the child had a disability. As in the past, the public agency must have known this before the behavior that precipitated the disciplinary action.
How do we determine whether the public agency knew the child had a disability before the incident occurred?
There are several circumstances included in the final Part B regulations. The public agency would have knowledge that the child was a child with a disability if, before the behavior occurred, the parent expressed concern in writing that the child needs special education and related services. These concerns need to be addressed to supervisory or administrative personnel of the appropriate educational agency or to a teacher of the child.
Would an example of that be where the public agency has received a letter from the parent requesting special education and related services, but the agency has not yet conducted an evaluation or made a determination of eligibility?
That's right. And the public agency also would know if the parent had requested an evaluation of the child under Part B. It also would know if the teacher or other LEA personnel expressed specific concerns directly to the director of special education of the agency or to other supervisory personnel of the agency about a pattern of behavior demonstrated by the child.
The final regulations also establish some exceptions to the public agency's basis of knowledge. A public agency would not know the child was a child with a disability if the parent of the child has not allowed an evaluation of the child or has refused services under Part B of the IDEA and the final regulations.
The agency also would not know if the child was evaluated, but was determined not to be a child with a disability for Part B purposes.
Have we covered most of the changes related specifically to discipline?
I think it would be helpful for us to talk a little bit about due process. Parents have the right to request a due process hearing if they disagree with the decisions made during implementation of the discipline provisions. But the statute made a number of changes regarding due process that are also in the final regulations. And we should remember that the LEA also continues to have the right to a due process hearing in disciplinary situations.
We already mentioned that a decision to change placement is subject to review through due process and judicial proceedings. The final regulations specify that a parent who disagrees with any decision regarding placement may appeal the decision by requesting a due process hearing. If the LEA believes that maintaining the current placement is substantially likely to result in injury to the child or others, it also may request a hearing.
In making the determination on a parent's or an LEA's claims, the hearing officer may return the child to the placement from which the child was removed. This would occur if the hearing officer determined that the removal was a violation of the discipline provision or determined that the child's behavior was a manifestation of the child's disability.
Or the hearing officer can order the child moved to an appropriate interim alternative educational setting for not more than 45 school days. If the hearing officer determines that maintaining the child's current placement is substantially likely to result in injury to the child or others. The final Part B regulations also allow for these procedures to be repeated if the LEA believes that returning the child to the original placement is substantially likely to result in injury to the child or others.
There's also a provision for an expedited due process hearing. Under this provision, the SEA or LEA, as appropriate, is responsible for arranging the expedited due process hearing within 20 school days of the date the complaint requesting the hearing is filed. The hearing officer must make a determination within 10 school days after the hearing.
During an earlier discussion about procedural safeguards, I learned that there is now a requirement for a meeting to try and resolve the issues prior to a due process hearing. How does the expedited due process provision affect this resolution meeting timeline?
I just want to preface this by saying that unless we specify school days or business days, we are talking about calendar days. A resolution meeting must be held within 15 days of the date the parent's due process complaint is filed. For an expedited due process hearing request, the resolution meeting must be held within 7 days of the appropriate educational agencies receiving notice of the due process complaint. Alternatively, the parents and LEA can agree in writing to waive the resolution meeting or agree to use the mediation process.
Under the regular due process procedures, the due process hearing proceeds unless the matter has been resolved to the satisfaction of both parties within 30 days of the receipt of the due process complaint. It's important to note here that a state may establish different state-imposed procedural rules for expedited due process hearings conducted under the discipline provisions than those that it has established under other due process hearings. But, except for the timeline modifications we've discussed, the state must ensure that the due process hearing requirements under IDEA are met.
And decisions made in expedited due process hearings can be appealed in the same way as other due process hearing decisions.
Where is the child during the due process hearing?
When a parent or the LEA appeals a decision under the discipline provisions, the child must remain in the interim alternative educational setting until one of the following things happens. The hearing officer issues the decision, or you reach the end of the removal period where the removal is related to weapons, drugs, or serious bodily injury, or you reach the end of the removal period for a change of placement for behavior that is not a manifestation of the disability. However, as with regular hearings, the parent and the SEA or LEA can agree otherwise.
This is a lot of information and very detailed. What would each of you like the audience to take away as the major changes to remember?
I think it's important for parents and school personnel to be aware of the new authority that is given to school personnel to consider unique circumstances on a case-by-case basis and to expand the removal authority of school personnel to include serious bodily injury in addition to drugs and weapons as a special circumstance. I also think the new standard for making the manifestation determination, as well as the changes related to expedited due process hearings on disciplinary issues, are important.
Renee?
I hope parents and public agencies pay particular attention to the educational services provided to children with disabilities under the discipline provisions. Even more important is that IEP teams continue to work to incorporate positive behavioral interventions and supports based on functional behavioral assessments into the IEPs of children with behavioral challenges. This reduces the necessity for using the discipline provisions. We'd like to see the focus maintained on supporting children and parents and helping children with behavioral issues become well-educated, productive adults.
That's a focus we can all appreciate and support. Thanks, Renee, and thank you, Mike. I appreciate your being here today to talk with us about these important provisions. This video is one in a series prepared by the U.S. Department of Education, Office of Special Education Programs, or OSEP, to assist our stakeholders in better understanding some of the significant provisions of the final regulations implementing IDEA 2004 that were published in the Federal Register on August 14, 2006. We hope you found it helpful, and we thank you for your attention.